Well, firstly, I'm actually appalled at one particular paragraph in this open letter that the Law Society has done, and that is to try and bring the office of the Speaker in disrepute. If you read the second last paragraph, and they've obviously got the law wrong too, it kind of bothers me, because I know there's a few lawyers who've got together and written this. It says, with respect to restrict matters of such great public importance to 1 hour's parliamentary debate, as suggested by the Speaker of the House, would be a serious failure of leadership. The Speaker of the House does not decide the 1 hour debate time. I'm sure most of you know about that. It's the motion that's put on the floor, understanding Orders 51. The Law Society's got that even wrong. It has nothing to do with the Speaker. The Speaker entertains the motion that was put on the floor. And the motion was to present these two bills, understanding Orders 51, and as Standing Orders 51 stipulate, then you can put various conditions, which was put in the motion. And then, as you know, on that day, there was absolutely no objection to that motion by even the opposition. So the Law Society has not only got the law wrong, but they have done a great injustice to the Speaker in insinuating that he has done something wrong, that he is the one who set the 1 hour debate time. It's not the Honourable Speaker who's done that. It's the motion that was put on the floor, which got passed without any objection. So the Law Society has got it wrong in the first place. And to say it would be a serious failure of leadership, how dare they do that? How dare they actually attack the Speaker who has conduct of the legislature? And frankly, it's not even worth responding to all the other issues that the Law Society is putting. But I will do that. And you need to highlight this issue. The Law Society has got that wrong. And it would appear to me that they are playing politics, because this is precisely the agenda that SODELPA and NFP were trying to highlight, indirectly or indirectly, questioning the leadership of the Honourable Speaker. And here we have the Law Society doing the same thing again and getting the law wrong. That's what they've done. So the question the public needs to ask, is the Law Society the mouthpiece of the opposition, or they're writing this open letter independently? It is very important for you to highlight this anomaly. Now, let me highlight the other issues that they've got wrong. In respect of, they're saying that our assessor system we share with nearly all other common law jurisdictions, including Australia, New Zealand, United Kingdom, who use the jury system in the same manner. Incorrect. The jury system in Australia and New Zealand says once you have a jury, which we don't have, the decision or the verdict of the jury must be followed by the courts. In Fiji, assessors, their outcome or their assessment need not be followed by the judge. It is optional. So they've got that wrong also, to try and draw some sort of similarity to that. Fundamental error in law. Fundamental error in facts. Now, secondly, they have said that by removing the assessors, and mind you, we actually had an entire session at the AG's conference, I think it was in 2017. We had a number of panel discussants regarding that, open to discussions by members on the floor. Close to about 400 people attended that particular forum, lawyers. They're saying by removing that we are actually going to public participation, that it will undermine public confidence. What sort of public confidence are they talking about? We've had situations where assessors in sexual offences, for example, have found a verdict or given an assessment of saying not guilty. Not guilty. And in some instances, the judges have overridden them. And you go back and look at some of those cases, similar incidences, similar facts, similar situations, same law, where they have found a guilty assessment and the judges have not overturned it. So there is a lack of inconsistency. And similarly, when you actually have, and I'll tell you, when you actually have decisions that are made by the assessors, the judges don't really have to give full reasoning. They simply just rely on the not guilty or guilty assessment. That's it. So how will the jurisprudence develop? Those of you who know criminal law would know only a few years ago with the offense of rape. Today we have the offense of sexual assault. In sexual assault cases, it's not only about penetration of penis in the vagina, it's all about all other objects. The law has developed. We need to develop the jurisprudence. We have now children, for example, who may be molested, who may be raped, etc., or using the old terminology, raped. But when you have also patriarchal notions in society, you will get enormously conflicting decisions being made by assessors. The whole point is to get a consistency in the law. So you develop proper jurisprudence. And also it will ensure that the judges will actually develop a system within themselves. They'll be able to have consistency too. So if a judge, ostensibly you can argue and say, if the judge on that day may not necessarily be feeling, willing to do that much work, so I'll just rely on the assessor and say, well, the assessor found him not guilty, and therefore I'll go along with it. But on some other occasion, he may feel a bit more energetic and decide to overrule. This is what we are saying. There needs to be consistency in the decision-making process. Fiji and Vanuatu are the only two Pacific Island countries that's got this type of system. So again, they've got that facts wrong. Now, the other issue that I wanted to also raise is that if you look at it from a practical perspective, you find there's only a handful of assessors, about 30, 40 assessors who are doing the circuit. Unlike other jurisdictions with proper jury systems, people are selected from the electoral rolls, etc. There's a particular level of sensitization in society regarding the new laws. Whereas when we have a handful of assessors doing the rounds, there's also untoward behavior that can take place. So whilst we develop the jurisprudence, getting a consistent system in place, obviously in a few years' time this position can be reviewed. Now, the other point that also I wanted to make was regarding the anti-corruption division, right, about the division in courts. We already have a family law division, right? We already have an employment court separation, where family employment matters go toward them. In Australia, New Zealand, in UK, where we common law actually starts from, they have a commercial division, admiralty division. Nobody there questions the acumen of the judges. Here they are saying that by creating a separate division, we are saying somehow the other that the judges, are not necessarily have the right acumen. Obviously, we're not saying that. There needs to be developed. We need to develop specialization, particular level of sensitivities, particular level of understanding what the law is, a specialist area. And they have the audacity to say that corruption is not so complex, that it is not so widespread. Please tell them to go and talk to the United Nations Office of Drugs and Crime, UNODC, that deals with us in respect of our ratification of the Convention, United Nations Convention Against Corruption. They will tell you a different story. Talk to Transparency International. And to say, I don't know who wrote this, this statement from the Law Society. Well, his name is not there, so it just says Law Society. But I'm saying whoever wrote it, or group of people wrote it, may not necessarily be practicing in that area, or may be able to try and obfuscate over some of the practical issues relating to corruption in Fiji. Don't have an understanding of it. Now, they're also saying that, what about sexual offense and child protection? There's obviously new laws that have been put in place. The Child Safety Act. The DPP's office is a separate division in dealing with sexual offences. Judiciary is doing their training. And if you actually go into the criminal cases that we've got, obviously there's been an increase. By removing corruption from that, in the separate field, you'll be diverting more resources to the area of what they talk about, sexual offences, child protection. That's already being done. This will give those judges the opportunity to deal with them. We also, I can give you numerous examples about how there's been inconsistency in decision making. A magistrate sitting in somewhere in, say, Lautoka gives a different ruling to somebody in, say, sitting in Lambasa or in Suva. We've also had instances, and I highlighted this at the GPH when there was the launch with the United Nations on the Bribery Day, Against Bribery Day, and I highlighted a number of case law also, where the law in this area has developed quite significantly in the UK, in Hong Kong, where common law is applied. Yet we find judges who are not being given the training, they don't have that level of sensitization. We need to develop that. Corruption is a bane on our society. It corrodes public confidence. It undermines the economy. So there needs to be an emphasis given to it. I mean, they are the sort of comments that I like to make. I think it's completely nonsense to say that corruption is not complex or not so wide. So there are my comments.